Hey, thank you, Laura, for the introduction. And hello, everyone joining us today here for the Dutch employment law. Hi, workshop. I'm here together with my colleague Peter de Ruiter today. Trying to see how I can go to the next slide. Like this. So you can also see us on the screen, but here's a nice corporate picture of us as well. So today we're gonna talk you through some high-level Dutch employment law topics, and just a bit background about ourselves. We both work as employment lawyers for the law firm Pallas Advocaten. We have offices in Rotterdam and Amsterdam as well. And our entire office is specialized in employment law. So all our colleagues deal with employment law 24/7 a day, which is what we like to do the most and know a lot about. And we're going to share some of that with you today. So my colleague Peter will start.
Thank you, Michelle. So as you already mentioned, I'm also an employment lawyer at Pallas, and yeah, very excited to gonna tell you a little bit more about Dutch employment law today. I will start off with some general topics of Dutch employment law, types of employment, restrictive clauses in the employment contract, but also sickness, and last but not least, termination. After that, Michelle will tell something about cross-border employment and remote working. So yeah, let's start off with the types of employment we have in the Netherlands. And first of all, that's the permanent employment contract, which is the most commonly used form of employment in the Netherlands, also called the contract for indefinite period of time, which more or less speaks for itself. Secondly, we have the temporary employment contract, so the fixed term employment contract, and there are some statutory provisions about that. So as an employer and an employee, you can agree upon a chain of temporary employment contract. What does that mean? Is that you can offer a total of maximum of 3 temporary employment contracts with a maximum total contract period of 3 years. So for example, in case you have 3 temporary employment contracts of 7 months, and after 21 months you get the 4th temporary employment contract, then that employment contract is perceived as an employment contract for indefinite period of time, even though you have not reached the maximum of 3 years. However, you have exceeded the amount of 3 temporary employment contracts. So that's how more or less a temporary employment contract works in the chain of temporary employment contracts. Next, we got the flexible hours employment contracts, which means that we got a minimum and a maximum employment contract. So how does it work? You can agree upon with the employer that, for example, you have a minimum amount of fixed hours per week, let's say 24. So you will at least get paid 24 hours per week. And if you're working more, then you get paid those hours more. So for example, a fixed range could be that your minimum is 24 hours and your maximum is, for example, 32 or 40. Then we also have an so-called on-call contract, which is more or less the same than a minimum maximum. However, in an on-call contract, you have 0 hours. So you will only get paid in principle for the hours that you work. There are a lot of exceptions about that. I will not discuss them right now, but that's in essence how an on-call contract works. So we also have an agency contract, which means that you have a temporary agency contract with a temporary agency, and the temporary agency posts the worker to a hire. That's another company. So the temporary worker works under the guidance and supervision of that company. However, you are formally employed with a temporary employment agency. Last but not least, not really an employment contract, but we also got the form of independent contractor. So freelance, that kind of contract does not fall within the scope of Dutch employment law per se, but I think it's important to note, of course, that you can also agree upon an independent contractor. Yeah, maybe it's also good to know regarding collective labor agreements, because we have a lot of them in the Netherlands. So it's good to take that into account, because in collective labor agreements, you can deviate from Dutch employment law, for example, with respect to the chain of employment contracts. So that's good to take into account. All right, we can move on to the restrictive clauses in the employment contract. And we included the most commonly used in the employment contract. We not listed all of them. We first have suspensive conditions in the employment contract, and maybe good to know for expats international is that what we see in practice is that a lot of employers include a suspensive condition in an employment contract that the employment contract will not enter into force as long as you don't have a valid work permit, for example, in the Netherlands. So then only your contract will only come into force when you can show that work permit. You could also get a resolutive condition, which means that your employment contract would end in case that condition is fulfilled. And that condition is quite exceptional and not commonly used. However, we see them, for example, in case you would lose your valid work permit. So that it's included in the contract that in case you would lose your work permit in the Netherlands, then your contract will end. Next up, we got the confidentiality clause. It's pretty self-explanatory, I think. And then we have the probationary period. So we also know the probationary period in the Netherlands, which means that each of the parties, so both the employee as the employer, can terminate the employment contract during the probationary period with immediate effect. There are some rules about that. So in case you have an employment contract for a fixed amount of time, and that's more than 6 months, but less than 2 years, you can include 1 month of probationary period. In the case you have a contract that's less than 6 months, you can, in principle, not include a probationary period. And in case your temporary contract is for longer than 2 years or a contract for indefinite period of time, you can agree upon 2 months of notice period, 2 months of probationary period. Please know that in principle, this can only be used in your first employment contract. So it's not possible to first offer someone a temporary employment contract, including a probationary period, and to also include a probationary period in the consecutive second temporary employment contract. And then moving on to non-compete clause. With non-compete clause, there are quite less statutory restrictions about a non-compete. The most important one is that non-compete clauses are in principle not allowed in temporary employment contracts. However, in case it is included in a contract for indefinite period of time, there are not a lot of restrictions for the employer to take into account. So in general, our advice is, in case you would sign such a contract, including non-compete clause, take a good look at it, make sure that it's not too restrictive and that you still have your hands wide open after your employment to search for another job. The same goes with respect to a relationship clause, which in essence means, of course, that you cannot approach any of the relations of your formal employer. Then last but not least, we got a non-solicitation clause, which are quite regularly included in an employment contract, and which means that you cannot entice away any employees from your former employer. All right, we're gonna move on. Sickness, and sickness in the Netherlands, if we explain that to expats or to employers or someone else who's interested in Dutch employment law, it's always quite extraordinary, because they also always find it very strange how it works in the Netherlands, because the principal rule in the Netherlands is that an employer is obligated to continue to pay salary during sickness of an employee for a maximum period of 2 years. So that's quite a long time. And of course, during that period, both the employer as the employee will have to make efforts with respect to reintegration. So you have to visit a company doctor, you have to make a plan of approach with respect to reintegration, all that kind of things. And it's also good to know as an employee, in case you do not meet those obligations, this could lead to a suspension and or withholding of your salary. Also good to know, for that's more or less the risk of the employer is that in case the employer would not meet his reintegration obligation, so in case you're not called up with the company doctor or your plan of approach has been made up too late, the UWV, the Dutch Labor Office, can impose a penalty to the employer, which means that the employer will have to pay, continue to pay the salary for an additional year. So that would be in total 3 years of sickness pay. So that more or less headlines regarding sickness. There are a lot of other rules also, but for now I will keep it to the main part. All right, then we end up to most I call it the most sexiest part of Dutch employment law, and that's termination. We also got a quite extraordinary system of termination in the Netherlands, because in principle, as an employer, you will need prior approval to terminate a contract. I here listed all possibilities on how to terminate an employment contract, but the most important ones are the employer giving notice through the Dutch Labor Office, which means that the employer will have to go to the Dutch Labor Office to apply for a dismissal permit in order to terminate the employment contract of an employee. And an employer will have to do that in case of long-term illness. So in case someone is sick for longer than 2 years or 3 years in case a penalty is imposed, or in case of restructuring of the organization, so redundancy. The other route that an employer has to take is that it has to go to court. But also with respect to court, it has to request the court to terminate the employment. So the employer cannot terminate upfront. No, it first have to go to court, and the court will decide whether or not the employment contract is dissolved. Those are the two most important aspects with respect to termination. I will walk through now the other ones, and that's of course your employment contract can end during the probationary period, because in that scenario the employer can terminate with immediate effect. It doesn't need a statutory ground for termination. Of course, your employment contract can end by operation of law in case of a temporary employment contract, for example. Mutual consent, which is also often used because an employer most likely doesn't want to go to the UWV or to the court, so we'll try to settle and try to agree upon a settlement agreement in which the employment contract is terminated with mutual consent. Then you have termination due to urgent reasons. That's quite exceptional. So you have to think about fraud, theft, or something like that, violence on the worker in the workplace, etc. So that's quite uncommon. The employee, of course, giving notice. In principle, an employee has a notice period of 1 month in the Netherlands. By operation of law, in case of the employee's death, so then also your employment contract will obviously end, and due to reaching the pensionable age. All right, let's continue. Yeah, so I already mentioned a bit about prior approval. So what I said, business reasons, so redundancy and long-term illness. In that case, the employer will need to go to the UWV in order to get a dismissal permit. And in case it would go to the court, it will have to go for statutory grounds of termination. So in case you would go to the court, the employer will have to show, I want to terminate the employment contract based on this termination ground. And those grounds, the most common grounds are underperformance, disturbed employment relationship, and culpable behavior of the employee. Please note that it's quite hard for an employer to meet the legal thresholds to fulfill such a statutory termination ground. It's not that easy. For example, with underperformance, you cannot just say, I think you're underperforming and we're going to the court. No, you have to make up a substantial file. You have to give the employee the amount of time, a reasonable amount of time to try and improve his performance. And only after then you can go to court and successfully ask for termination. All right, let's move on. Also, of course, an important aspect in case of termination is severance and termination pay. So under Dutch law, we have a so-called transition fee, which is a fee that an employee is eligible to, or always entitled to in case of termination. the termination has, of course, taken place on the initiative of the employer. So, and you're always eligible to a transition fee. So, for example, even if your employment contract is terminated during your probationary period, so after 1 or 2 months, also in that scenario, as an employee, you are entitled to a transition fee. So what's the amount of transition fee you're entitled to? That's 1/3 of a monthly salary per service year. And that's, of course, calculated pro rata in case the employment hasn't lasted longer than 1 year or is terminated during the year. The maximum of the transition fee is 84,000 euros gross, or a yearly salary in case that's higher. And of course, there are options in court to ask for an additional fair, so-called fair compensation. To be eligible for such fair compensation, as an employee, will need to demonstrate that your employer acted seriously culpable, which again is a pretty high legal threshold to meet, but of course it's not impossible. But again, that's something you will have to go to court for. Also, it's possible to get an additional compensation, for example, in a social plan. So what a lot of employers do is that in case of a redundancy or restructuring in which a lot of people get redundant, the employer drafts up the social plan. And in that social plan, they, for example, agree upon a severance payment, which is higher than someone's transition fee. And in that way, they want to try to provide the employee with an incentive to agree upon, for example, a settlement agreement, instead of that the employer will have to go to the UWV to ask for a dismissal permit. Of course, besides fair compensation and social plan, and like I just said, you can agree upon termination with mutual consent. And like I said, most employers try to settle your termination instead of going to the UWV or the court, and that could be a reason to agree upon a higher severance payment than the transition fee. All right, I think I've covered all my topics, so I will give the word to my colleague Michelle about cross-border employment.
So maybe just a quick suggestion, because I see we have sufficient time. Perhaps there are already questions about the first part.
I have a question. What is about the 30% ruling? I heard of it, but I never know about it.
Yeah, that's a tax benefit. So that's meant for people who come from abroad and get a job in the Netherlands. So you have to be recruited from abroad and then go to the Netherlands to work there. And there is a special tax benefit for people from abroad, which is that 30% tax ruling, which basically means that 30% of your gross salary is not taxed. So the employer can deduct 30% of your gross salary. That's not taxed, and only the remaining part of your salary will be taxed. So it's actually aimed to create an attractive climate here in the Netherlands to get people to work here. And you can apply that for a few years even. So it's pretty generous, I would say. There is a certain salary threshold that you need to meet to be able to be eligible for that ruling. But if you meet all the criteria, you can apply for it. Your employer has to do that and apply with it with the Dutch tax authorities. And then if it's granted, then you can pay less tax for a few years.
Thank you very much.
Maybe in addition to that, a severance payment is fully taxed and does not fall under the 30% tax ruling, unfortunately.
Okay, thank you for clearing.
No problem. Any other questions? Otherwise, we'll just continue with the second part. No, okay. All right, so like I said in the beginning, Peter and I are both employment lawyers working in employment law 24/7, and we have an extra specialty, I would say, and that is international employment law, or cross-border employment, if you want. I think that's also one of the reasons that we are connected to the Expat Center here in Rotterdam, because they are specialized in cross-border employment as well. So we just wanted to give you a bit more background on what it means for us that we consider ourselves international employment lawyers, because employment law, although it's at least from our perspective, a very important part, is definitely not the only aspect of working abroad. There are several other aspects that are just as important to take into account. For example, wage and income tax are also an important aspect. The 30% tax ruling that you just mentioned is just one of the examples that are important to take into consideration. But also the question where you have to pay tax, depending on where you work, where you live, etc., is always very important in international situations. On top of that, social security is also very important. If something happens to you, you want to make sure that you are covered by an insurance, unemployment benefits or sickness benefits. And if you're working abroad, then you need to make sure that the social security is in place and that you're covered in the country where you want to be covered, and make sure that there is no gap there as well. Another important issue is, of course, immigration law. Are you allowed to work where you want to work? Which permits do you need? How do you get them, etc.? But could also have an impact, like Peter just discussed, on your employment contract. If you don't get it in time, it may not start. If you lose it, it may end your contract. So that's also a pretty important aspect. And then there's also the matter of pension, which of course is also a very important part of working and the future. Can you keep building up pension if you're temporarily working abroad? If you have worked in several countries, are you building up pension in all kinds of countries? How are you able to enjoy that pension once the time is there? So that's also a very important aspect of our work. That doesn't mean that we advise on all these aspects. We mainly focus on employment law, but because these are topics that we come across every day, we know on a high level basis the basics, and if necessary, we involve other partners from our network to help us with those topics. And I think, like Laura said in the beginning, the Expat Center is really good one-stop shop for all these aspects to start and get your information. And I think it's very helpful for expats to have such a place where you can get all that information just under one roof. So that's very good. And what I have learned from the past years in my experience as an employment lawyer is that every aspect has impact on the other. So if you choose a certain employment law, it has an impact on social security. If you move to a country where the taxes are different, it could have an impact on your pension, etc. So you always need to take all these aspects into account, and changing one or the other will almost always have an impact on the other aspects. And I think that's also one of the more fun parts of our work, that it's never straightforward, and keeps it interesting as well. So what we did for today is just a short presentation on more the employment law aspects related to expats and international employment. We listed a few important aspects. There are, of course, a lot of things to think about when you come to the Netherlands to work here, like where you want to live, where are your kids going to school, is your husband or wife also happy with where they are, and can they find a job, etc. From an employment law perspective, I think one of the important things to consider is if you have the necessary permits to work here, which I think is one of the starting points. Especially during the current COVID pandemic, there are still possible travel restrictions to the Netherlands. We get those a lot in our practice. I think probably the Expat Center as well. employers or employees calling that they have a job where they start the 1st of November, but they're not able to travel to the Netherlands yet. And what do we have to do now? And can we start, or what's going to happen? So we see that a lot at the moment, which, well, makes it interesting, but also difficult at the same time, especially for people wanting to come over here. And then there's also, of course, the important aspect of checking your employment contract, especially also in relation to this COVID situation. And one of the things that Peter also just discussed is the suspensive condition, especially given the current COVID pandemic. We see a lot of more employers who include such a condition in the contract. Because if you want to have someone working here from the Netherlands and you really need them to be here in the Netherlands and they can't come here, for example, because of travel restrictions, a suspensive condition makes sure that the starting date of the employment contract is suspended until that person actually arrives in the Netherlands. So it actually says once you have your visa or once you have arrived in the Netherlands, then the employment contract will start. So even though the contract mentions as a starting date 1st of November, for example, but you won't be able to come here on the 1st of December, then your employment contract doesn't come into effect. And the most important part about that for the employer is, of course, that they don't have to pay the salary over the first month because your employment contract hasn't started yet. So it's important to check for employees coming here if such a condition is in your contract, because it may mean that your salary payments are not going to start yet because your employment contract hasn't started. A solution is also to agree upon a later starting date. If the employer doesn't have such a condition in the contract, but you are not able to travel yet, it's always possible to agree between both parties to start later, if that's better or in the benefit of both parties. Another important thing to check, and it's probably 99% out of 100 times going to be in your contract, is a probationary period. So, for example, if there isn't a suspensive condition and you're not able to agree on a later starting date, the employer is forcing you to come to the Netherlands, but you're not able to, then both parties can use the probationary period as a solution as well. So both parties can invoke the probationary period and say, okay, I terminate the contract with immediate effect, and then it's over. Of course, not the preferable way, but at least be aware that this may be a possibility. And you can even make use of it before the starting date of the contract. You can have a discussion whether that's legally valid or not, because the probationary period is used to discover if you think that this will be a good working relationship, and if you haven't worked for a day, how can you assess that and already make use of the probationary period? But yeah, in most cases, judges will allow making use of the probationary period in that way. And of course, another important aspect is always to check which law is applicable to the contract, because you need to know under which rules and regulations you will fall. Most likely, if you're coming from abroad to the Netherlands, it will be Dutch employment law, but it's always good to double check. So we were also asked by Laura to touch upon the topic of remote working, which is, of course, something that we are all doing. Peter and I are also not in our office, but at the Venture Cafe working remotely. So I think it's something that we have all experienced over the last 1.5 years, but it's also a big discussion at the moment because we're moving a bit more towards returning to the office. Not everyone wants to return to the office. And yeah, you can see a lot of movement on that topic right now. So I think it's also good to shortly discuss it. The legal starting point in terms of remote working is that your employment contract will state where you are required to work. So there will be a clause in the contract that says the employee will perform their duties from his home office or from the office in Rotterdam or something like that. That is something that you agree upon in the contract, and that's also leading in principle. The place of work that is included in your contract cannot just be changed unilaterally by either the employee or the employer. So your employer cannot say, hey, I know we agreed that you will work in Rotterdam, but I changed my mind and I actually want you to work from Eindhoven or maybe even from Belgium. It can be for a shorter period of time. So if you need to visit a customer in a certain city, of course, you're supposed to go there, but you can't just change the place where you work entirely, which also means that you can't just say to your employer, okay, thank you, but I think I'm going to work from Italy instead of Rotterdam. So that's not something you can just unilaterally decide. Which also leads to the conclusion that remote working is actually only possible if agreed upon between the employee and the employer. Our observation over the last year and a half, but maybe more so the last months, is that employers now seem to be more willing to allow employees to at least temporarily work from another country. It differs a bit on the company, whether they consider that a good thing, whether they want their employees to fully return, whether they will allow you to work from your vacation house in Spain or not. But it seems to be a bit more easy to do so at the moment. How it will be in the future, I'm not sure. But I think that the last year has definitely shown that it is possible to work remotely. But yeah, like I said, this is still something that you need to agree upon if that's what you want to keep on doing in the future. So there are, in terms of remote working, a few possible situations. I've outlined two for today. The first one is that your employment contract starts maybe on the 1st of November, but you're still abroad, not yet arrived in the Netherlands. The other option could be that you have already come to the Netherlands, you're working here, but you want to return to your home country to work from there, either permanently or temporarily. I think those are the two main situations we see in our practice, at least. And there are a few options to how to deal with that. Allowing people to work remotely for a temporarily period of time is one of the options. So for a few months. And the reason for doing that temporarily is that if you go back to this picture, once you work abroad for a certain amount of time, this all changes. So the starting point, if you're in the Netherlands, is Dutch employment law, Dutch wage tax, Dutch social security, Dutch pension. But as soon as you work for a few months abroad, it may all change. So a different employment law system may be applicable. You need to pay taxes in a different country. You need to be insured there. So that is the reason why it's usually only allowed for a certain period of time to work remote, because it will have quite a big impact if you stay there for longer. Not all companies realize this. Maybe they are starting to now, but this is very important to consider, because it will at least be quite an administrative burden, but it could also cost you a lot of money if that's not arranged properly. So what we see in our practice is that if you do get your employer to agree upon working remote for a certain period of time, most likely they will always want to get something in writing, like an addendum to the employment contract, to make some agreements about how you will deal with working remotely. One of the items is in relation to what I just said, that is agreeing upon an ultimate date on which you should return to the Netherlands, to make sure that it is only temporarily that you're working from abroad. But also if people become sick, The employer in the Netherlands is still responsible for your sickness payment, for reintegration. And like Peter said, that could go on for 2 years. So the employer, of course, wants you to return to be able to fulfill their obligations in order to make sure that they are compliant with all the sickness regulations. And of course, doing regular checkups and reintegration from abroad is just simply not possible. I mean, you can be in contact, but it's not possible to meet all your obligations under all the Dutch benefits, sickness regulations if you're abroad. And finally, most of the times employers also want you to keep your address in the Netherlands. There are a few reasons for that. First of all, they still need, of course, a place where they can reach you, send you letters, send your pay slips, etc. But it's also because if in a worst case scenario, you would end up in a court case, which is of course really the worst case scenario. If the employer starts a court case against the employee, they should do it with the court where the employee lives. So you can imagine if the employee travels to America, maybe for 3 months, and the employer wants to fire you because it's just not working out, they would have to start a court case in America if that is where your new home address is. Because if you're no longer registered in the Netherlands as living there, then it's not possible to start that court case in the Netherlands. So that's also one that always is very important to consider. Then there are some consequences if the remote working is not temporarily. I think the first one I already mentioned is that the applicable labor law can change. So we have European legislation, which is applicable in cross-border situations. And that European legislation determines which law is applicable to the employment contract. And the general rule is that the labor law that's applicable to the contract is the law of the country where you usually carry out your duties. So if you're working in the Netherlands for 100% of your time, then you're usually or habitually performing your work in the Netherlands, and then Dutch law will be applicable to the contract. If you work remotely in, let's say, France for a year, full-time, then France is actually the place where you usually carry out your work. And then the employee has the possibility to claim that French law is also applicable to the contract and not Dutch law, because that is not where he's working. So that's a very important one from an employment law perspective, that it's very important to keep in mind that the longer someone is abroad and the more clear it is maybe from the beginning that it's going to be a long or temporary situation, is that the applicable labor law may change. And that's, yeah, well, depending on which law is applicable, I would say either in favor or not of the employee. But this is this can lead to quite complicated situations, especially if in the employment contract you made a choice for the applicable law. So you can include a choice of law in the contract. So if you have included Dutch law in the contract, and then based on the European legislation, French law is applicable, then you have 2 employment law systems that are applicable. And then you have to decide which one to follow, how to apply that. And that's usually explained in favor of the employee. So that's very important. Another consequence if remote working is not temporarily, and if you don't return to the Netherlands on the agreed upon deadline, what may happen is that the employer will ask you to agree upon a new contract based on the law of the country where you want to stay. So, for example, in the example that I just discussed, you started working in the Netherlands and then moved to France and have been working there for a year. There is quite a big risk that French law will be applicable to your contract. If you then say to your employer, well, I have no intention of returning to the Netherlands, I want to stay here in France, then the employer might say, okay, that's fine, but then we're going to change your contract to a contract that's ruled by French law, because that's where you're working. And then you can work from there, but then under the applicable rules in France. So that could be a solution, but that's of course something the employer also has to facilitate. And then they should also be aware of what French employment law includes, etc. But that could be an option. Another option is also that if you do not return to the Netherlands on the agreed upon deadline, that the employer has a reason to terminate your contract. I recently had a situation where I was assisting a Dutch university, and they had a lady who worked there who decided to immigrate to Spain, which I'm quite jealous of, actually. Would be nice to do, but she just decided I'm going to go to Spain. And then she actually assumed that she would be able to work for the university from Spain, which she never really cleared with the university. So then she explained her plans to go to Spain and give up her house and move everything to Spain. And then the university said, yeah, that's okay, but you can't work for us from there. She said, why not? I can do it online, etc. But as an employer, you are the one that determines where you perform the work. And if it's a Dutch university, I think there's a lot to say for the fact that that should be performed from the Netherlands. So they had quite a big discussion about that. And in the end, the contract was terminated, and she found another job in Spain. But yeah, that's just an example of how this situation can play out if you, well, either don't make good arrangements about it, or if you just want to go abroad for a longer period of time, which may eventually result in the termination of the contract. And finally, in any case, reintegration obligations for the sickness payment under Dutch law always remain applicable if you are abroad. So you still need to be available for your employer, etc. So it's not possible to get away from that if you're abroad. Then I have one last sheet, which is actually maybe a bit of a niche topic, but I'm not sure, Laura, Daniel, do you have highly skilled migrants also with the Expat Center every now and then? Yeah. So that's the final one I just wanted to quickly mention, because we see that a lot as well. That if you come here to the Netherlands on a highly skilled migrant visa, there are also a lot of consequences if you lose that. The first one being that you're no longer allowed to work here in the Netherlands. And if, like Peter mentioned before, you have a resolutive condition in the contract that says if you lose this visa, the contract will end, then that's clear. But if that's not included in the contract, you have a different discussion. One of the things that is important to keep in mind as an employee working on such a visa is that the employer is obliged to investigate if you can be reassigned within the company globally. If it's a global company and you lose your highly skilled migrant visa, they still need to see if they can find you another position where you can work without the visa. If that's not possible, then the other option is to agree upon a termination by mutual consent. And if that's not possible, then the employer ultimately will have to go to the court and request permission to terminate the contract. And the ground for termination will then be that the employment contract has become meaningless. Well, in principle, it says that you're no longer able to perform your work because you're not able to be in the Netherlands. And that is a reason for terminating the contract. You are still entitled to financial compensation in that case. So that is maybe one of the more positive things. And another option that we always advise people to look into is that if you lose your highly skilled migrant visa, there's always an option to see if you can get an employment through a payroll agency that is a recognized sponsor and that can employ you, which may allow you to continue working here in the Netherlands as a solution. But then you would have to find an agency willing to take you on, and the employer should also, of course, be willing to work together with that agency to keep you working. But sometimes that can be a lifesaver if both parties want to continue working, but the visa is the only obstacle keeping them from doing that. Okay, so that's all I wanted to discuss with you today. Does anyone have any questions?
Yes, I have a question. It is a little bit regarding to COVID, and it's out of your experience dealing with contracts. So how the COVID actually affected the compensation packages for the new contract, like in COVID, of course, and comparing it to what was before offered?
Well, it depends, I think, a bit on the situation. So the transition fee that Peter mentioned is a statutory entitlement. So it's difficult to get that lower. So I think that has still been the at least the minimum amount paid to employees. What we do see is that companies who are having a hard time because of COVID, having a loss in turnover, maybe have to downsize, that there is, much lower termination fees being paid than before COVID. Sometimes it's simply not possible because they don't have the money to do so. But it can be tougher to get higher compensations because of that. So that is definitely something that we have seen. Are those the situations that you meant, or were you thinking about other? Yeah.
Correct, exactly. These are the one that I was. I had the idea about it, but also regarding to tax benefits or what the government actually reacted to organizations and the benefits that the government gave. Also, was it included in the compensation, and somehow did it need to be adjusted in the employment contract, or was it in which phase they did it?
I'm not sure I understand your last question.
So there were some compensation from the government that was paid, right,
to the companies,
to pay to their employees. And how did they agree on these terms? Was it mentioned in an addendum, in an added document to the contract, or like another negotiations through?
So there was indeed the subsidy from the government, the NOW in Dutch. I apologize for not having the English translation ready for you, but I think we mean the same one. But that's mainly something between the government and the companies. And the purpose of that subsidy was for the companies to be able to continue paying wages. So it's not so much termination fees, but just the regular salary that people were entitled to. So the subsidy was not meant for termination fees or stuff like that. It was mainly to allow the company to continue paying salary to their employees.
Maybe in addition to that, is that the government made certain conditions to that compensation package to employers, one of which was that in the beginning that as an employer you cannot lay off any employees if you wanted to apply for such a compensation. So what did you see is that, especially in the beginning of COVID, a lot of companies hesitated to restructure or to lay off employees because they wanted to apply for compensation. And now we see that as that compensation is being reduced, that a lot of employees now are making the decision, okay, are going to restructure or not, because it seems like the economy is a little bit bouncing back. So yeah, we are as employment lawyers more or less waiting. Is there still coming a big wave of terminations due to redundancy? But yeah, we'll have to wait and see. But with respect to the compensation package of the government to employers, yeah, it's especially in the beginning quite common not to lay off any people, because that was one of the conditions in order to apply for the NOA.
Yeah, thank you very much for the answers.
No problem. All right. Are there any other questions?
Maybe I have actually one.
Yeah, sure.
Sure.
A question we get a lot from also employers, but also on the hand, what we see expats, they expect when they have a labor agreement in the Netherlands that and working from remote, for example, from the US, that they are still getting an the residence card. But that's I think not needed, right? Because you're not physically here in the Netherlands working, you work from abroad. And the second thing, you need to register in order to keep your residence permit. Is that correct?
Yeah, I think it is. I think you need to be physically in the Netherlands to come and pick up your residence card. And as long as you're not physically here, I don't think you will be able to obtain it. Yeah, I think that's correct. Yeah.
Thanks.
Any other questions? No? Then we did a good job, I guess.